I've got to tell you, be careful with your exemption classifications. That is something that I want to stress. Those are the types of things that the Department of Labor field enforcement officers are looking for. We're getting more and more buzz about misclassifications of exempt employees. If you have not done an audit of your exempt employees, I encourage you to do that now, because many times people assume, well, this person has always been exempt, so they should continue to be exempt, and they haven't really looked at the requirements of an exemption. There are 6 types of exemptions, and many people think, well, there are 6 tests, let's just say, on one of them. Oh, well, they meet 4 of the 6, so it's okay. You have to meet all 6 of the requirements for someone to be considered an exempt employee. We have a great tool. It's an exemption worksheet. It's a program that gives you all 6 of the exempt statuses. And if you would like a copy of those worksheets, Scott can email those to you. Each of you in your packet has a CEA evaluation form. It looks like this. And if you want to, if you're so kind, we're also going to raffle off some labor law posters. If you want to put that at the back of the sheet, anything that I may have mentioned or the exempt worksheets, we'll be sure to get those emailed out to you. But definitely something that if you haven't taken a look at it in a while, they are really, really cracking down on that. And the penalties are extremely high for this classification. You are not only liable for back, meal, and rest period penalties, overtime, as well as some tax implications that can be had for the employer and the employee. So just make sure, if you haven't done that in a while, that might be something that you want to do.
This program, I was going to say, this program, we don't have a whole lot of time to go over specifically exempt status and what that is and what that means to you. But I just want to reiterate that this is a serious issue. This is a whole seminar all on its own. It's classification, exempt versus non-exempt employees. Please, if you have any salaried employees, if you pay anybody a salary and you don't pay them overtime, and you're making the assumption that they are exempt, please audit them this year. These exemptions change every year. If you did it 3 years ago, they're different than what they are now. So please put down on there you want those exempt status sheets, and I would audit sheets, and I will email them to you. They're just too large, too many pages for me to print them off. These were tough enough. It was added another 14 pages, 21 pages to it. So please put it down there, and I'll email them to you. They're a PDF form, and you can print them off, and you can pick the paper name.
It's something that you really are going to want to, if you haven't looked at it, in at least 2 years, I would say even 2 years, because it changes every year. And a lot of times people, they haven't had an opportunity to increase rates of pay, specifically like with the computer exemption, computer professional exemptions now that would require an increase in pay to those folks. So that tends to be one of the most misclassified, to be honest with you, are your IT folks. So that's definitely one. And administrative.
I find office managers. How many people have office managers that make $30,000 a year and pay them salary?
Don't be shy.
Don't be shy. Don't worry. Just comment.
Oh, more, just
less.
30.
Less than 30 or less. Okay, because the cutoff is 33 something or other.
33,280
and automatically they don't qualify if you're paying them less than 30.
All right, Senate Bill 117, health insurance benefits. This is for state government contractors who provide medical insurance benefits to employees and dependents. They must also provide benefits to employees with same-sex spouses and registered domestic partners. This is already a rule. It just broadens it with the same-sex spouses. If your carrier says they don't want to cover same-sex marriages, you need to tell them that they have to do it here in California. So that's just a new regulation that came out. Senate Bill 651, domestic partnerships. This bill loosens the requirements for establishing a domestic partnership in California. Any guidelines, plans, forms, or policies that describe domestic partnership requirements that are inconsistent with these changes need to be revised. There were many inequalities that existed between marriages and domestic partnerships in California. An example, the law previously requested that couples who wish to enter into a domestic partnership must be living together, although they didn't have that same requirement for married couples of the opposite sex. So Senate Bill 651 corrects this problem. and other differences that remain between marriage and domestic partnerships. And this just brings us one step closer to equality, and we're just, of course, awaiting the final ruling under the federal regulations to support this particular bill that we have currently in California. AB 887 talks about gender discrimination. This further clarified gender identity and gender expression. Okay? This revises the definition of gender in the California Fair Employment and Housing Act, making it clear that discrimination is on the basis of gender identity and gender expression, and that it's strictly prohibited. Gender expression means basically a person's gender-related appearance and behavior, whether or not it is stereotypical of the gender that they are associated with or the gender that they're assigned at birth. Okay? So this amendment is retroactive because it clarifies rather than changes the law. This new law makes it clear that discrimination on the basis of gender identity and gender expression is illegal. And again, this is something, gender expression means that maybe someone behaves in a certain way or has mannerisms that are against what their assigned gender is at birth. And you cannot discriminate against someone because of that. Okay? We actually have a free webinar on March 21st on this particular topic. You can sign up at CEA at our website, www.employers.org, if you want some additional information about gender identity and gender information.
Can you repeat the website, please?
It's www.employers.org. Okay. Assembly Bill 228, Workers' Compensation. California employers insured by State Compensation Insurance Fund now must obtain separate workers' compensation policies to cover their employees who work out of state other than temporarily. This is under, again, this will let state fund, very interesting, they have a monopoly on this sort of thing, provide workers' compensation coverage to California-based employers for all of its employees, regardless if they work in or out of California. Assembly Bill 22, this is a big one, related to consumer credit reports. Okay, be careful with your third-party background checks. It's not okay to do bundles and check credit on everyone, only those who qualify. And they have stiffened the regulations as to who qualifies. Okay, employers currently may request a consumer credit report for purposes of evaluating an applicant or an employee for employment, reassignment, or retention. Under Assembly Bill 22, it prohibits an employer or a prospective employer from obtaining a consumer credit report unless the person for whom the report is sought has or will have a position that is, one, managerial, where information contained in that report is required by law to be disclosed or obtained, or that person is handling or has access to $10,000 or more in cash during the workday, or that person has access to regular personal and financial information, or someone that's authorized to transfer money on behalf of the employee or the employer. So you have to have a very specific reason to obtain a credit report anymore. And many times what people do is they say, oh, well, you know, I've got this third-party background check company, and they give us a great deal for 20 bucks, we get everything. You can no longer run the credit report unless it's based on the job and you can prove it with the job description and these circumstances. Any questions about that? Any of you do third-party background? You can still run the criminal, you can still run the reference checks, all those kind of things. It's just